Yeah, 10 minutes. We're good, great. Okay, we're good. Stephanie, would you, unless there's an objection, I'm going to reset the county attorney's clock to 7 minutes. You're back on, and I believe you were just about to transition to the argument on the particularized harm, but you start where you want, but we were paying attention.
Thank you very much. Just to touch one more point, just to close out on this slide, if we could, is that the position is that the zoning administrator's letter Z-Corp 2021-0233 in this case did not grant or deny the appellants any personal property, any personal or property right. The letter that was requested to the zoning administrator asked prospectively whether a use would be permitted, and the zoning administrator responded saying it could be. There was no pending application, so therefore these cases really stand for that proposition that something more is needed for it to be a determination, and thus trigger 15.2-2311. Moving on to the second issue of standing, which we touched on, the particularized harms, as Mr. Clark had mentioned. Yes, the position is that the appellants lack standing under 15.2-2311 under the Supreme Court's test in Friends of Rappahannock. It's a two-part test. As I mentioned, it has to be in close to the property. The person must own or occupy real property in close proximity. And the second, they have to allege facts demonstrating a particularized harm different from the public in general. In this case, as cited, as referenced in the staff report, Friends of Rappahannock, the appellants there, neighbors, there was a quarry that a sand and gravel mining operation going up, and the particularized harms were alleged in Friends, had to do with noise, barge, certain possible environmental concerns, and the Supreme Court said it was too. It was not. It didn't meet the test. The county does concede that the first prong has been met, and that they occupy property in close proximity. But it's the particularized harm, because if I can read it, and each appellant must demonstrate that reduction of property values and risks to safety and property because of commercial traffic and crime. In this case, our position is that they lack the particularized harm that the Friends case requires. At that point, I would like to pause there and ask if, because we're asking this to be decided before we reach the merits, I was going to invite either the appellants and the property owner to speak on it, or if the board wishes us to proceed with the full case.
I'll let the board do me a favor, stop the speaker's clock, because we're back to sort of board time here. I'll ask for your opinion on this. It appears to me that these issues break down on the first question about an advisory opinion, that appears to be purely a legal question. The second question about the particularized harm strikes me as one that would be dependent on evidence of particularized harm, and that a hearing on that matter is appropriate to see if any evidence is adduced for that. And then, of course, on the third question, if we get past the first two, the whole enchilada, that, of course, would be subject to everything in the public hearing. So I'm going to ask, in order, again, to be respectful of everybody's time and to keep things from being confusing, I think the appropriate thing would be to allow everyone to address all three of these issues, let people adduce whatever evidence is necessary. I may ask, if it's the board's pleasure, to bifurcate the questions, just handle the first question of aggrievement on advisory opinion, debate that, depending on the answer, maybe proceed to the second question that may have some factual basis, and then in the third, go to the whole enchilada. I know that's a lot, but I'm going to ask, is there any objection to us proceeding to a full hearing on all of the questions, and we'll manage the work of how to break down the deciding questions? No. Any objection? Okay, I'm going to note that there are no objections to that. So thank you. What we're going to do is turn your clock back on and ask you to please address the, I guess, as I've so eloquently put it, the whole enchilada, and then we'll ask the other two parties to address them all as well.
Mr. Chair, before we begin, I would like to maybe ask if the BZA would grant additional time, because to present the whole merits of the case, it's probably going to take more than 4 minutes, I'm pretty sure. And of course, we'd be willing to also allow the others the same additional time that we would need.
How much time do you think you need to do a full presentation?
Probably about 8
You
minutes.
tested it. Another eight, so a total of 18 minutes? A total of 18 minutes? Or, no, 8 minutes from here.
8 minutes from here, so another additional 4 or 5 minutes.
An additional, so 15 minutes for all parties. Do I hear a motion that we grant the three parties in interest 15 minutes? Any debate? Any objections? All right, we'll note that that's unanimous as well. So please, if you would reset to 10 minutes, and we're back to the point of the beginning, at least with the clock.
Okay.
Thank you.
Thank you. The properties subject to Appeal 2021-3 are depicted in yellow on the screen. All are zoned AR1 Agricultural Rural 1 under the revised 1993 Loudoun County Zoning Ordinance. The subject properties are located at 20191, 20179, and 20173 Gleedsville Road, Leesburg, Virginia, and encompass 4.9, 8.01, and 2.26 acres respectively. A complete chronological history of Appeal 21-3 can be found on page 3 of the Zoning Administrator Staff Report. The subject of Appeal 2021-003 is the zoning determination issued in response to a request by representatives of Newport Academy for determination that the proposed use, as described, would be considered occupancy of a dwelling single-family detached and permitted as a matter of right on each of the subject properties in accordance with Virginia Code Section 15.2-2291A upon appropriate licensure from the Virginia Department of Behavioral Health and Developmental Services, VDB HDS. The proposed use was described as a single-sex group residential facility for no more than 8 adolescents with 1 or more non-resident staff persons. Each of the properties would be licensed by the VDB HDS. Residents would participate in individual therapy, group therapy, academic study, and a variety of other activities. The residents of each facility would not have access to the other 2 properties. The length of stay would be typically between 30 and 90 days. Newport Academy stated it would not operate drug rehabilitation facilities or provide substance abuse treatment at the properties, and any resident determined to be using alcohol or other drugs would be subject to immediate discharge. The zoning administrator acted on the request for a determination based on the description of the proposed use presented. C-Corps 2021-233 indicated that a congregate housing facility is a use not permitted in the AR1 zoning district. However, based on the information presented, the zoning administrator determined that the proposed use would be permitted as a dwelling single-family detached use on each of the subject properties if it meets the definition of family under the zoning ordinance and the criteria of Virginia Code Section 15.2-2291A. Article 8 of the zoning ordinance defines dwelling single-family detached as a residential dwelling unit other than a portable dwelling designated for and occupied for one family only. Dwelling single-family detached is a permitted use in the AR1 zoning district as evidenced by the AR1 use table in Table 2-102 of Section 2-102. A single-family dwelling is defined as occupation by one family. Family is defined in Article 8 of the zoning ordinance as including any group identified in Section 15.2-2291. Therefore, if the proposed use meets the criteria of Section 15.2-2291, it is permitted as a single-family dwelling in the AR1 zoning district. In Section 15.2-2291, the Virginia Code provides specific direction as to how group homes and residential facilities with 8 or fewer individuals with mental illness, intellectual disability, or developmental disabilities are to be considered by zoning ordinances. A residential facility meeting the criteria of Section 15.2-2291 is considered as residential occupancy by a single family for zoning purposes. No conditions more restrictive than those imposed on residences occupied by persons related by blood, marriage, or adoption shall be imposed on such facility. Therefore, if no more than 8 individuals with mental illness, intellectual disability, or developmental disabilities reside at each of the subject properties, and each of the residential facilities are licensed by VDB HDS, The subject properties are single-family residential dwellings that are permitted uses in the AR1 zoning district. Thus, the zoning administrator's determination in Z-Cor 2021-233 is correct, and the board must uphold the determination. The zoning administrator has consistently opined that uses that meet the zoning ordinance definition of family, including groups identified in section 15.2-2291, are single-family dwellings and are permitted in zoning districts where such use is allowed. Examples of previous determinations and zoning permits issued for properties to be used by such groups are included in attachments 9 and 10 of the staff report. The appellants make three arguments with which the zoning administrator disagrees. First, the appellant's argument that the use of the property as an alleged commercial treatment-focused use is not allowed in a single-family home within the AR1 zoning district is incorrect. As discussed earlier, if the proposed use has no more than 8 individuals in residence within one of the groups identified in section 15.22291 and is licensed by VDB HDS, it is considered residential occupancy by a single family and is a permitted use in the AR1 zoning district. Second, the appellants argue that section 15.22291 does not mandate commercial uses in residential zones. The zoning administrator disagrees. Section 15.22291 does not distinguish between commercial and non-commercial residential facilities. In fact, a Virginia General Assembly bill proposed in 2000 sought to amend Section 15.22291 to distinguish between profit and nonprofit residential facilities. That bill did not pass. Further, the Attorney General opined that the proposed amendment would violate the Virginia Fair Housing Law. Thus, the purported commercial business model of Newport Academy is irrelevant to the issues before the BZA. Third, the appellants argue that the proposed use is not entitled to protection under Section 15.22291A because the proposed occupation by persons addicted to a controlled substance. Newport Academy stated in its request that it does not seek to operate a drug rehabilitation facility or provide detoxification services and will not admit a resident who is currently using illicit substances, and any resident who is determined to be using alcohol or other drugs will be subject to immediate administrative discharge.
Excuse me, Michelle, your slide
totally
is up there if you want to take a second and put up the right slide.
Sorry, my precious time.
Let me remind everyone, please, to silence your phones, turn them off. It not only disturbs the meeting, but it interferes with the recording process.
Last, the appellants suggest that because the residents receiving mental health treatment will reside there for a limited time, that this is somehow a violation. However, the appellants fail to cite any Virginia code or zoning ordinance requirement that supports that position. Section 15.22291 expressly states that no conditions more restrictive than those imposed on residences occupied by persons related by blood, marriage, or adoption shall be imposed on such facility. Therefore, the resident's duration of stay for treatment is not relevant to any issue before the BZA. In conclusion, the zoning administrator respectfully requests the Board of Zoning Appeals to uphold Z-Cor 21-233 and deny Appeal 2021-3, as the use would be permitted as a single-family detached dwelling on each subject property, and as the proposed use meets the definition of family under the zoning ordinance and the criteria of Section 15.22291A of the Code of Virginia. If the proposed use has no more than 8 individuals in residence within one of the groups identified in Section 15.22291 and meets the criteria of that section, it is considered residential occupancy by a single family. Dwelling single family detached is a permitted use in the AR1 zoning district, and whether the residential facility is operated by a commercial or non-commercial entity is not relevant to locate a residential facility on each of the subject properties, and licensure of the VDHDS is required to meet Section 15.22291A. This concludes staff presentation, and the zoning administrator respectfully requests the Board of Zoning Appeals uphold Z-Cor 2020-233 and deny Appeal 2021-3.
Thank you very much for the staff report. Very well done. I know I appreciate you being tolerant of the interruptions. But let me turn to the members of the board now and see if there are any questions for county staff.
Mr. Chairman,
Moffitt.
I have a number of questions. First of all, while this decision was in progress, the staff was in communication with the owners, not only Newport, but also with the owners of the houses that were going to be up for sale. That's correct, isn't it? in fact, I mean, the owners
The request
were
came from Newport, the request came from representatives of Newport Academy. The only contact I had with the property owners was through asking if the determination had been completed yet.
And those property owners were basically saying is we really need this because we want to know whether to sell our houses and to move on. That is correct. I think I saw that in the record.
That was the only comment. Yeah, that's the gist of the conversation that I had with the owner, yes.
All right.
With one of the owners.
So, secondly, is there any indication in the November 29th letter that this is simply an advisory opinion? It's characterized as a determination, it gives appeal rights and everything else, and it's clear, it seems to me, is that any number of people relied then and rely now on this letter. So just dealing with the advisory opinion issue, I don't see any language in here characterizing it as such, and it's clear that Newport and everybody else relied on this determination in moving forward. Is that a correct characterization?
In terms of the, let me just, if I could speak to the advisory versus the language and the determination, but this is a determination letter. One of the key issues, one of the key aspects of the cases that we had cited in the report is that even though it may say determination, you have to look at the substance of it as well. For instance, Graydon Manor, which was just recently decided, I know it, folks, because it was just recent, I don't have it before you, so I'm happy to provide supplemental information on that. But that too also had the determination. The court said, no, looking at this in totality, this was an advisory opinion. So too with the Crucible case, which we cited, they asked for a verification letter. They got a verification letter. So too the court said it's considered advisory because there has to be something more. And in this case, if we look at it, the perspective from the request to the zoning administrator, as well as the response is, we're thinking of buying these properties. Here is proposal, how do you respond? And the response was the interpretation based on the code.
The clear intent of this, I mean, the clear intent of this is that if you go ahead and apply for a zoning permit using the exact language that you used here, we're going to grant the permit? I mean, that's clear from the letter, isn't it?
But that doesn't necessarily flow from it. That they may not. Because no application still has been received or processed. They may not.
All right.
They may not invest it or whatever. They may not buy the property. In other words, it's a speculative process.
But I mean, the letter clearly indicates, seems to me, is that this is what is permitted, and if you file the zoning permit, then it's going to qualify. All right, but let me move on because I have several other questions. I want to make sure that the staff's position is, you said that this is, which I think quite correct, is that this would be a congregate housing facility and would be allowed as a congregate housing facility, right?
Would be allowed in districts that permit congregate housing.
Exactly, excuse me. So there is an option for them to apply as a congregate housing facility. I think all of us feel for the persons that are going to be using this, and my heart certainly goes out to the folks and to their parents for this, but there is another option open to them. And then secondly, I want to make sure the staff says is that for this district, the only thing that would allow it is section 15.2-2291. That is correct. That's what the staff's position is, right?
Right. And for clarification, Mr. Moffitt, the congregate living use is not permitted in the AR1 zoning district.
I understand.
You understood that? Okay. I thought you said
I understood.
that is an option.
But that would be presumably be allowed in another district under different requirements. So that option is open to Newport, and the only question here tonight is, does 15.2-2291 allow use of these 3 residences for this facility. I just want to make sure. Okay. 15.2-2291 says that only certain people fit the description here. Individuals with mental illness, intellectual disability, or developmental disabilities. I'm presuming that we're talking about mental illness here. And what evidence did Newport present in its letter of September 22, 2021, which formed the basis for your determination? What evidence did they provide that the individuals in these proposed facilities would all be diagnosed, characterized, or whatever as having mental illness? To me, it's not good enough to just say as mental health symptoms, but in order to invoke 15.2-2291, there has to be some evidence that these individuals are suffering from mental illness. And I don't see any.
Yeah. Well, Mr. Moffett, I think from the determination standpoint, advisory opinion, whatever you want to call it, it would basically be dependent on whether or not this became a licensed facility as to whether it would be permitted in this, on these properties. So regardless of how they portrayed it to us, ultimately it's the call of the state in issuing a license as to whether they meet those criteria. So in the instance where the state would issue a license for this type of use, then the zoning ordinance would permit it as a group home. So it really falls down to whether or not this use gets a license or not. And if it does, it's permitted, and if it can't because it doesn't meet the criteria, then it would not be permitted.
On an actual application.
Correct.
So there's no evidence in the record that's before us now. And by the way, I think I have this correctly, is that they initially said in this application that this would be adolescents, right? I think in response to at least one landowner here, they said is, well, we may now have people in there 18 to 26. I'm sure I saw that. So the group of people that were initially listed as being here have now shifted. Is that correct?
We don't know that for certain, but that is something that you could ask the representatives of Newport Academy. And I do want to point out that we did respond to what was in the letter, and in the letter it does state that they would, each of the residences would be licensed by VDBHDS as an MH therapeutic group home for children and adolescents with serious emotional disturbance.
Yeah, so again, it would not be the zoning administrator that would make that call. It would be the state licensing agency that would actually make the call. We would just respond to what the state does, basically, in the licensing.
Are we going to be hearing, Mr. Chairman, from Newport?
Yes.
Yes. And to also add to that, there is no age requirement in that state code section.
Right. But I just want to be clear is when you issued the letter, there was no concrete evidence presented to you that these individuals in these homes would be characterized as having mental illness. That is correct, right?
Again, I think another reason for the argument of advisory opinion, at the time that they requested the letter, there was no application for license for this facility. There was no zoning permit application submitted for this type of facility. So it was clearly based on the description that was provided by the Newport Academy. And our answer was, again, it really kind of depends. If you're licensed under the state provision for a group home, then the zoning ordinance would allow the use as a residential single-family detached dwelling. So really, that's the test for zoning, is whether they're They're a licensed facility.
Any more questions, Mr. Moffett?
Not for the moment.
Okay. Mr. Silverenko, Mr. Walker, any questions?
Nothing.
I do. I believe Mr. Moffett has hit an important point that the board's going to have to be able to get to here. And I think this actually gets right to the question that was before the Supreme Court as to why we don't have appeals over matters that aren't the subject of an application, because it seems to me that it is arguably, in every case, speculative. And I think under the Supreme Court cases, the question is, as the local court said recently, what's in the letter from the county, not what's in the letter from the applicant. If this was a different question, like a variance application, we'd have to look at what did they ask for and what's the case. The question here, it seems to me, is do we have a narrow issue upon which we can adduce facts and get legal issues and then allow people to have their rights of appeal? So here's my question. So here's the point that I get to. When I look at the county attorney's letter issue, the county's letter issued by you, the substance starts with if. If the use, and then it quotes the state statute, if what you apply for meets the state statute, then you're in. The residential facility will require licensing through the Department of Behavioral Health and Developmental Services. To establish that use, you must apply for more permits. Now, here's my question. If it's decided tonight that purely as a matter of law and procedure that this should not go forward tonight because on the question of advisory opinion, however many of the people in the room here who consider themselves a aggrieved party are not done out of justice, they have an opportunity to pursue and come back probably to this body when there's an actual application with actual assertions of what's going to be done on the property with plats and four corners that the county is going to either rule on or for or against. That's my point. That the point here is, do the folks who consider themselves aggrieved have an opportunity to come back and address the issue if in fact an application is actually filed, that they're not out of court if we decide this issue on advisory opinion today, and there's an application that follows.
Yes, in short, Mr. Clark, it's premature, but nonetheless, if there's an application that was granted or even denied, that would be a different set of operative facts.
That's how I read those Supreme Court cases, is it doesn't do people out of justice or their day in court. It just says, let's do it when we actually have a case in dispute, not a vague letter where we've got to decide, are you looking at the applicant's letter, or are we looking at the county's letter, or whatever. That's how I take it. But I want to make sure that I feel and the other board members are clear that if that technical, very narrow decision is made tonight, it doesn't mean anybody here doesn't have a day in court. What they'll actually be is helped, because there will have to be binding legal assertions as to whether or not there's any drug treatment going on the facility, or whether people who are just simply feeling low get to move into the facility, that they've got to meet some, standard that we can then tear apart in a hearing at that time. All right. Any more, Mr. Moffett? You said at this time.
No, I'll have some more in a bit.
Okay. Then I think we should turn to Mr. Hampshire and the applicants. If you would reset our clock now to 15 minutes, Stephanie, and we'll hear from the appellants.
Good afternoon, Mr. Chairman, members of the Board of Zoning Appeals. I'm Gifford Hampshire with the firm of Blanky, Ship & Keith, and I represent the appellants. Mr. Chairman, both the county and Newport, as you've just heard, have challenged the standing of the adjacent landowners, and I'm grateful for the additional 5 minutes to deal with the standing issue. I will say very quickly that Vulcan Materials says specifically in the opinion at page Head Note 2, in the land use context, a landowner may be precluded from making a direct judicial attack on a zoning decision if the landowner has failed to exhaust adequate administrative remedies. The Vulcan opinion specifically held that there were no adequate administrative remedies precisely because there was no written determination in that case. And the Vulcan decision cites Rinker versus City of Fairfax, Gate and Triangle. There are other cases, Dick Kelly, and I can tell you one thing, that if the county would be the first one to say that if we did not appeal this letter, that we were precluded from making a judicial attack on the zoning determination. So to answer your question, Mr. Chairman, we would be precluded from making any sort of contest to the determination if we did not appeal this. And that's not just me saying that, that's the zoning administrator herself saying that in the determination letter, which you will see, and that is set forth in Virginia Code Section 15.2-2311, which says that appellants have a right to appeal a zoning determination. A zoning determination is important in this case precisely because the zoning determination determined that the use was a use by right in the AR1 district if only they got state licensure. So if Newport gets state licensure, the appellants have no recourse if they don't appeal this here today and get a ruling in their favor. And if they didn't appeal it, they are precluded from appealing to circuit court. So that's one answer. The Crucible case had nothing to do with standing. The Crucible case had to do with vested rights. And what happened in that case, and I just pulled it up in my phone, it had to do with whether or not the appellants were entitled to the plaintiffs were entitled to vested rights based upon a conversation that occurred in the county building. It had nothing to do with a written determination, a zoning determination. I don't know about what happened in the Gate and Triangle case because that just came out, Gate and Manor case, that just came out. But please be assured that the county would be the first one to say that we are out of court if we didn't appeal this as we have done. And they say so in their letter. So that's one point. So conscious of the time that we have, I'd like to turn the time over to Lynn Wright, who's one of the appellants who's going to testify about how she is aggrieved in this matter.
Thank you. Would you like to testify from the seated position? Or you may have a podium if you'd like. Whatever makes you more comfortable. Thank you for coming and participating tonight.
Is on?
And just to be clear, these are, you're speaking officially on behalf of all of the appellants.
Is this on? Okay. Good evening. My name is Lynn Wright. My family and I have lived on Gleedsville Road for 24 years. Our property borders the 3 homes and 25 acres that the Newport Healthcare recently purchased for a commercial treatment facility campus. I'm here to express concerns that my family and every adjacent neighbor have around Newport's plans to offer short-term commercial treatment of 24 adults in the middle of a residential neighborhood, a facility whose proposed use was initially deemed congregate housing by Loudoun County's Deputy Zoning Administrator and therefore not permissible by Loudoun zoning regulations. What changed that? I find it illogical that we, the appellants and adjacent neighbors, have to defend our standing in this hearing, we who live a stone's throw from this proposed facility. The Friends of the Rappahannock case that Newport and the Loudoun Zoning Board like to cite involved neighbors up and down a river who were not necessarily abutting the operation they were objecting to. Our appellants at all 6 adjacent family properties would absolutely suffer particularized harm different than the public at large. My backyard is an open area that connects to Newport's backyards and recreation area. One of the homes is 350 feet from mine. All adjacent neighbors have always been able to clearly hear and see the activities at the houses. We could hear the construction workers talking from 6 acres away. But those were sounds and sights from a family, not a congregate housing campus with 24 patients doing outside activities, deliveries, trash trucks, traffic from non-resident staffers, therapists, and visitors. All adjacent and close neighbors could not help but be affected by changes a commercial operation would bring. It would forever alter the residential neighborhood feel, environment, and tranquility. We, unlike other homes in Loudoun, will have to deal with any trespassers on our properties, any public disturbances, and emergency service responders. On record are reported disturbances from Newport facilities in McLean, and in 2021 alone, there were 110 reported 911 calls from the Bethlehem, Connecticut facility. This is not speculation. This is substantiated information from various neighborhoods and law enforcement facilities. This shows a pattern of poor management oversight, a lack of concern about how Newport treatment centers are run, and the kind of neighbors they may be. Last week, the Supreme Court of Virginia heard an appeal regarding a similar question of standing between McLean neighbors, Newport and Fairfax County. There, Justice Kelsey asked, quote, "Why wouldn't it be enough to establish standing that a commercial enterprise is put in a residential neighborhood, and the obvious dislocation of that concept being a particularized harm, irrespective whether you can nail down how many people run out or do wicked things? That is a bizarre thing if you're living in a neighborhood and have a commercial enterprise right next door. It obviously has risks associated with it," end quote. We ask the same concern of the Loudoun BZA today. Additionally, there is the very real matter of home devaluation. Real estate reports we submitted show an average devaluation of 12% for the properties near Newport's current location on Kurtz Road in McLean, despite an increase in home values across McLean. Our home equity will be diminished. There is also the personal concern of my family's ability to continue to safely host a local nonprofit called A Farm Less Ordinary on our land. For 3 years, A Farm Less Ordinary has successfully provided work opportunity, stability, and purpose to intellectually and developmentally disabled members of our community. More on this later. I ask this of you. In your mind's eye, picture the front of your house. Now imagine the 3 houses or buildings on the left or on the right have been purchased by a corporation to use as a treatment center for 24 transient adults with behavioral and emotional issues. How concerned would you be? Fairfax County upheld their rules against congregate housing in residential zones when Newport attempted to use a row of 3 houses to operate 24 client facility there. We implore you to do the same. Thank you.
Mr. Chairman, I'll continue in the interest of time. I'd just like to give a summary of my argument here because time is limited. The zoning administrator herself found the use to be a congregate housing facility that is defined not to be a single-family home in the definition. The heart of this case is whether a treatment facility must nevertheless be allowed pursuant to Virginia Code 15.2-2291. The plain language of that code section, the protection there applies only to residential facilities, and there's no indication of an intent by the General Assembly to supersede local zoning. Very basic principles of local zoning that say separate commercial uses from residential uses. The General Assembly knows how to say that. They didn't say that in this case. Newport's materials, moreover, show that it is soliciting advertising for people who may not be actively using controlled substances, but who are addicted to controlled substances. The words they use are substance abuse as a co-occurring diagnosis. That, enough in and of itself, is enough to disqualify them from the protection of the statute. So the heart of this case, again, is whether 15.2-2291 allows for treatment centers, enables the protection of treatment centers. If you look at the appendix, page 321, you will see that statute. You will see that residential is used 4 times. How many times do you see the word commercial used there? None. And significantly, in the last sentence, this is critical. For purposes of this subsection, residential facility means any group home or other residential facility. The General Assembly was clearly talking about protecting, pursuant to the Fair Housing Act, disabled people, mentally ill people from discrimination in what? Housing. Not promoting commercial treatment in residential zones. That's what's going on here. And it's very curious to me to understand how Loudoun County is so willing to divest itself of its zoning power to separate commercial uses from residential uses. But that is what's going on. The plain language of 2291 simply doesn't support their proposition. The purpose, if you look at the purpose of the AR1 district, it is to promote rural economy uses, with residential uses allowed at densities consistent with the general open and rural character of rural economy uses. And it's consistent with this intent that the Loudoun County Board of Supervisors said congregate housing facilities, because they focus on that kind of treatment, are not allowed in the AR1 zone. So how is it that the zoning administrator can say that this use is nevertheless allowed? The only basis, again, is to say that is that somehow this state law superseded local zoning. Now, that's a big deal. It's a big deal to say that the General Assembly has said, in this one instance, Loudoun County, Fairfax County, Prince William County, you can't separate residential uses from commercial uses. You can't do it. And we don't care what the effect is on your local residents. The General Assembly, again, knows how to say that. They did not say that here. The examples that are cited as supportive of their case are not. At page A323, there's an example about community residential care for retired veterans. There was no mention in that case of any sort of treatment at that facility. At A325, the National Children's Rehab case, that had nothing to do with commercial treatment. And in fact, if you look at that, at A328, there's a note by the zoning administrator, not enough information, and we're not attorneys, we can't interpret 2291. So why are they doing it now? At A329, the Potomac Road case, that was not a determination that the use would be allowed, but there was a note that it had to be a residential facility. At A330 at the bottom, therefore, in order for a what? For a residential facility to fall under State Code 2291, so forth and so on. So it all has to do with a residential facility. The case law with respect to prior interpretations is Trustees of Christ and St. Luke's Episcopal Church, and it says that a consistent administrative construction of an ordinance by officials charged with enforcement is entitled to great weight. There's nothing about these examples that show a consistent administrative interpretation that commercial uses are allowed in residential homes in the AR1 district, quite to the contrary. Lastly, 2291 explicitly removes protection for a couple things, including not just use of controlled substances, but addiction to controlled substances. That in and of itself, if that is present, says that the people who occupy that structure are not entitled to be treated as a family. But the evidence is overwhelming in the record that that is exactly what Newport is doing. There was an admission in the Fairfax case that that 20% of the Newport patients nationwide have a secondary diagnosis of substance abuse. And in the materials in the record, you will see how they refer to it as substance abuse as a co-occurring disorder. Now, Newport tacitly admits that they have these people here because they talk about drug testing. They talk about how the people will be subject to discharge if they're found to be using. Why do you need to test if people don't have a problem? They know very well that they have a problem. That's why they're testing. In the materials, we also cite the case of United States versus Southern Management, which is A214 and A220. That is the Fourth Circuit case that sets forth the standard for how to determine somebody is addicted, even if not using. And what the Fourth Circuit says is you have to have a period of abstinence, and you have to have some rehabilitation before you can admit somebody into a house and gain the protections of the Fair Housing Act. And we know from the record that Newport does just the opposite. It admits and deals with a problem later. That's not what is intended either by the Fair Housing Act or 15.220-291 that implements it. So for the argument, again, for the county and Newport to succeed, they have to demonstrate something that is contradicted by their filings, namely that these people don't have a problem, that they're not addicted. Again, I'm going to conclude where I started. The heart of the case is whether the treatment facility, whether 2291 provides protection to treatment facilities, whether there was an intent by the General Assembly to supersede local zoning or to provide protection to treatment centers in residential zones. There's no evidence in the plain language of the statute, the legislative history, and that AG opinion that is relied upon had nothing to do with the use on the property. It only had to do with the nature of the entity, whether the entity was a profit or nonprofit entity. That doesn't speak to what's going on the property. You can have residential uses that are for profit. You can have commercial uses that are for nonprofit. What matters is what is going on the property. Thank you.
Thank you, Mr. Hampshire. I'll turn to the board now. Does anybody have any questions for the appellants? Mr. Moffett, you're scooting forward.
Sir,
Yes, sir.
my understanding would be is that bear with me here for a minute. 2291 is really talking about a home where 8 individuals, either mentally ill or intellectually disabled, reside for a substantial period of time where they're treated like a family and where the purpose, I would think, is for them to be integrated into the community. And I think, as you mentioned, that the fair housing, this was intended from people discriminating against those individuals. And I sort of speak from experience because I had an uncle who was a schizophrenic. And he lived in such a home for 25 years. But there wasn't, but the purpose of that was really to treat him as part of a family and to get him out into the community and be able to use the services without being discriminated against simply because he was a schizophrenic. And that seems to me to be what you're arguing here, that these provision of all of these therapies, yogas, activities, and everything is not really that intent, which the General Assembly, which the state of Virginia and the code was intending. Do I have that correct?
Yes, sir, you do. As we say in our papers, the 1997 Fairfax Circuit Court case called Alternative House, which is in our materials, spoke to the issue, and it did, even though it's 24 years old and it was a circuit court case, it still seems to be the only case in Virginia that really speaks to the issue. And it says that the 15.22291 was enacted in response to the Fair Housing Act to prevent, as you say, discrimination in housing. And in that case, you had mentally ill children who had been abused, and if you've read the case, you'll see a footnote about all the horrible things that they had gone through. They had no other home to go to because their families were abusive. And they found this refuge. And the intent there was that they come and they have a safe place to live. And the court said they have no other place to go to, and therefore they reside there. Compare that with what we have here. What we have here is a young woman, not even children, but young women, who are coming with a specific intent to be treated, and with a specific intent not to come home at a particular period of time. Women who have homes, by definition they have homes. They're going back to their homes. Now, it is true in the case law that reside is kind of a fuzzy concept, and length of time is only one element. But there has to be an intent to treat something as your home in the first place. And when one hypothetical 18-year-old or 22-year-old enters through those doors, she is not thinking that this is her home. She's thinking, I'm going to be here for a certain period of time, which happens to coincide with when the insurance runs out, and then I'm going to go home, and I'm going to be cured, or I'm going to at least be better. That's the definition, as the zoning administrator says, of a congregate housing facility. And that's precisely why it's not allowed in the AR1 zone. But yet somehow the county and Newport say, never mind the zoning ordinance, the state code has come in and displaced all of that. Well, that's, as I said in my argument, that's a pretty bold thing to say. And if you're going to say that, you better come up with some evidence in the language of the statute, and there is none. In fact, all the legislative history is, again, as you say, Mr. Moffett, is to provide a place for people to live in a home where they don't have another home. So I hope that answers your question.
Any other questions from members of the board? Okay, I have. Mr. Hampshire, excellent presentation. You really helped us zero in on some issues. In fact, one of my questions you anticipated in your last 30 seconds as you were rounding third and heading for home, distinguishing the Attorney General opinion. So I appreciate that. Your point being that the Attorney General's discussion was about profit, not commercial and residential. So that point's very well taken. I want to first go back to the question of remedies of the people here tonight and whether or not they have another day in court. And I'm having some difficulty with that because the county's gone on record that there is another opportunity, but your assertion is you believe they would take the position that your clients are out of court. So I want to try to particularize that question. If this moves forward, it's going to be because there is an application and a permit is issued by the zoning department. I get your point, actually you didn't get to argue it, but you may now, that this letter includes the one we've seen in every determination letter, which basically doesn't say you have the right to appeal. It just advises them of what the code says, that people who are aggrieved have certain rights. But I believe I understand the point here is that everyone would agree, and I think that I don't want to put words in the county's mouth, that there would not be an appeal allowed of this letter after a permit is issued in the future. But aggrieved parties would have an appeal of the issuance of that permit. Do you disagree with that?
I do disagree with that.
Okay, but can you explain that to me, please?
Yes, and if you look at the determination letter, and it's found at A15, Appendix 15, and it says, this decision is final and unappealable if not appealed within 30 days. Here's your application packet if you don't do it. If you look at the Vulcan Materials case, since it was cited by the other side, and you look at Head Note 2, the Vulcan Materials case, it cites a line of cases there that is very well established. And in a previous life, I was an assistant county attorney in Prince William County, and we loved this line of cases. Because if somebody didn't appeal a zoning determination in 30 days to the Board of Zoning Appeals, they couldn't come along later and attack that decision, either through a collateral legal action, or if an administrative zoning permit were to issue later, they couldn't contest that zoning permit. And county attorneys, like I used to be, are very happy to say to a court they had a right to exhaust their administrative remedies by appealing to the Board of Zoning Appeals this determination, which is the substance of what allows the zoning permit to issue. They didn't do it. They're out of luck.
Even if your office had taken the position that that was an advisory, not conclusive, but an advisory in opinion.
Well, I take issue with that characterization. It's not advisory. It's only advisory in the sense that it's a zoning determination. I mean, every zoning determination is advisory in some way, shape, or form because the use has yet to occur. Zoning is only one stage. You still have to get an administrative zoning permit. You have to get site plan approval. You have to satisfy any other number of requirements. Zoning is just entitlement to do something. And so this determination is final vis-a-vis entitlement, legal entitlement to go get that license and to have that use administratively without the ability of anybody to attack it legally.
Okay, thank you. I think I understand your point very well. The last question that I have relates to the issue of whether or not state law is superseding county law, which I don't think is the case because the county is citing a specific county ordinance that includes by reference the state statute 15.2, 2291. If you meet the state statute, you're a family, and that essentially kicks open the door, if you accept that you're within the definition of the state statute, to be in whatever entitlement you would have if you meet the definition of family. But that's important because as you point out, this question of the drug use, illegal drug use or addiction to controlled substances, I think is very important. And I'm going to ask you to challenge what I think is the plain reading of this, that that zoning ordinances must include, this is the incorporation by reference, I'm reading 2291 now, shall consider a residential facility in which no more than 8 individuals with mental illness and intellectual disability or developmental disabilities reside, with 1 or more resident or non-resident staff persons as residential occupancy by a single family. Okay, that I think the import of that is to say, counties, you must heed this principle. Then there's a clarifying sentence that says, for purposes of this subsection, mental illness, which is one of the things that establishes your inclusion in the club.
Right.
Okay? And developmental disability, another thing that establishes your position in the club, shall not include current illegal use of or addiction to controlled substances as defined under another code section. Doesn't that simply say that you're not in the club because you claim your drug use or addiction is a mental illness? Isn't that different than saying you may have an addiction, but you're still in the club because you meet the Department of Behavioral Services definition of mentally ill, intellectually disabled, or developmentally disabled? You see the point that I'm focusing on here is that you're saying that it seems to say that regardless of anything else in the section, if you've got an addiction or a substance abuse problem, you're not in the club. I think that sentence simply says your drug addiction or your illegal drug use does not get you in the club, but I don't see how it's a bar. Can you help me with that?
Yes, sir, I'll try. What this state code section does, again, it implements the Federal Fair Housing Act that was designed, again, to prevent discrimination in housing. And so the state of the Commonwealth of Virginia comes in and enacts this statute that is a control on local zoning. We admit that it is a control on local zoning. What it says is that if you are a mentally ill person, as defined, you are entitled, if there's a residential facility that is composed of 8 or less mentally ill persons, then you have to be treated. Localities have to treat that house, that residence, as single-family residential. So in order to qualify for the protection, you have to be mentally ill. What the statute goes on to say is, Mr. Moffitt's point about what is mental illness, the General Assembly is saying one thing that mental illness is not is addiction to a controlled substance. So if you've got people in a residential facility that are addicts, whether or not they're currently using, that facility is not entitled to be treated as single-family residential.
That's my point. It doesn't say that. It says you can't use that as a justification to claim you're mentally ill. So let's have an example, and I'm not going to use his relative because I don't know him and I don't want to besmirch him. John Doe has paranoid schizophrenia, is on 16 medications that are absolutely legal to treat mental illness as determined by Dr. Fauci or whoever is appropriate, but at the same time is addicted to OxyContin. Why doesn't this person get in the club because of his 18 medications and his paranoid schizophrenia? He's just simply not getting in because of his addiction to OxyContin.
Let me see if I can answer. I think the language we have to look at is the very first half of the sentence. Zoning ordinances for all purposes shall consider a residential facility in which no more than 8 people with a mental illness reside as single-family residential. So if you're not mentally ill, or if you're addicted, then the localities are not required to treat such a home as single-family residential pursuant to this section. It relates to what kind of people are in the home. Are they really disabled? Are they really mentally ill? And if they're addicted, if they're addicts, they're not mentally ill and under this section, entitled to the protection, and therefore localities are not required to treat that home as single-family residential.
I get all of that. But what if there is a clear and distinct diagnosis that you have, I guess I have to clarify my example, 2 mental illnesses? It's possible, isn't it? One of which is a direct result of your addiction, and the other is mental retardation. I'm not even sure that's an appropriate phrase anymore. A developmental delay. It has nothing to do with your drugs. I want to make sure I understand. You're saying this second sentence, which says mental illness shall not include the drug abuse or addiction, is actually a trump of the first sentence that could have been, if they could have been written, regardless of the previous sentence, anybody with a drug use or addiction does not meet the definition in the first sentence and is not in the club. I think that's how you are interpreting it. I know yes. I'm not expecting you to defend the authors of the statute.
Right.
But you get my point here.
Right.
I think.
I think I do.
I think your reading of this is too narrow, and maybe the Department of Behavioral Services has to make this determination, that there has to be, if drug abuse and addiction is one of your reasons for claiming a mental illness, you're not in the club unless you can establish a totally separate mental illness, disability, or whatever that's not related to the drug addiction. Wouldn't you agree with that?
I agree that under the language of the statute, and I grant you that statutes are not always models of clarity.
That's true.
But this one seems to be very clear that if you are addicted to a controlled substance, localities, and if that's what's really going on, people are coming there because they're addicts, then you're not entitled to be treated as a residential facility as defined here. But I want to hasten to add that our argument does not rise or fall on that issue. Our argument, as I said in the beginning, really is, does the protection of 15.2-2291 extend to treatment centers, commercial treatment centers, such that the distinction in the Loudoun County Zoning Ordinance and the AR1 district between residential uses and congregate housing facilities doesn't apply? And we say that there's nothing in this statute that derogates local zoning, derogates the AR1 district to allow commercial treatment centers in the AR1 district, to allow congregate housing facilities that the zoning administrator herself found to be not allowed in the AR1 district. There's no intent of that. And therefore, the zoning administrator is plainly wrong in saying that notwithstanding the prohibition of a congregate housing facility, it's allowed anyway. That's our point.
Thank you for that. Appreciate it very much.
Thanks.
I threw a lot of meat out there. Anybody have a question before we go on next? All right, then that will end our appellant's presentation. Do we have anyone to speak on behalf of the parties in interest? I think now the owners of the property? Yes? Would you please state your name for the record? And you'll have 15 minutes to present on behalf of the property owners.
Thank you. Members of the board, let me first thank you for the opportunity to speak. My name is Joe Procopio, and I'm the CEO for Newport Healthcare. Frankly, I don't envy your job this evening. I simply ask that you separate emotion from the law and that you separate speculation from the truth. I think individually, my job here is probably the easiest, and it's to talk about the need for our type of services. I think most people in the room, including those who are our most vocal opponents, would agree there is a need for more mental health services in Northern Virginia. The question tonight before you is whether or not the zoning ordinance and Virginia law deem Newport's group homes in Gleadville a by right use. Others more versed in that topic will speak to the law, and I'll turn it over to our attorney shortly. But what I would like to impress upon you is an understanding of the importance of upholding the determination by the zoning administrator. As we've seen in the past several weeks from the CDC, and more recently as last Sunday from the New York Times, we're in the midst of a mental health crisis with our adolescents and young adults. It didn't just start the last 2 years. It's been prevalent for the last decade, and it's just been exacerbated by the pandemic itself. In the United States, NAMI, the National Alliance of Mental Health Illness, reports that 1 in 3 young adults ages 18 to 25 suffer from a mental health illness, and 1 in 10 have a serious mental health issue. We know that mental health begins, 50% of mental health issues begin at the age of 14 and 75% by the age of 24. Young adults 18 to 25 have the highest prevalence of mental illness, the highest prevalence of serious mental illnesses compared to all other age groups, and they're the lowest served. They have the lowest percentage of people who actually get help. So the most acute and the least served. In Virginia, and in particular here in Northern Virginia, it's no exception. In Virginia, 1.3 million Virginians have a mental health condition amongst adults. That's roughly 3 times the size of Loudoun County. 750,000 adults in Northern Virginia have a mental health need, and 370,000 want services but can't find them. That's according to the Community Foundation for Northern Virginia. In 2019, 8% of the population was dealing with an active symptoms of anxiety and depression. Now that figure is 28%, fourfold, impacting 500,000 adults here in Northern Virginia. Virginia ranks 42nd among states for the highest prevalence of mental health illnesses and the lowest access to treatment. In our business, Newport's, here in Virginia, when we started 2018, we were receiving about 100 calls a year for help from families in crisis. Those numbers this year will top 800. Issues like anxiety and depression left unaddressed manifest themselves into self-medication, self-harm, major depressive disorder, suicidal ideations, and in some cases, suicide itself. Suicide has risen by 25% in Virginia. Suicide is now the second leading cause of death among our young people. And in 2020, 233 Virginians between the ages of 18 and 28 committed suicide, took their own lives. If you think about what we, Newport, are trying to do, it's to focus on intercepting the disease early in someone's life to put people, young people, on a better trajectory. How are we going to accomplish this? We've worked in a group home setting since 2009. So we've been providing services similar to what we're asking to provide here in this county for almost 12 years, 13 years actually. We provide high quality therapeutic services to individuals and their families. These services take place in a home-like setting, family-like environment that we're proposing here in Gleesville Road. Our young adult programs work in small cohorts, so we'll group kids in 6 to 8 pods, and we'll serve them with 2 therapists, an individual therapist and a family therapist. And the sole responsibility of those therapists will be on those 6 to 8 young adults, 6 to 8 residents. We'll use talk therapy like CBT, cognitive behavioral health, DBT, attachment-based family therapy. We combine that with experiential services like music, art, adventure therapy. We establish right at the admission process that the families need to be involved. So there's a high intensity in terms of providing family services. And we think the combination of those, talk therapy, experiential, making sure that the family's involved, create great outcomes. And you'll hear from some of our clients and possibly have received letters from them talking about the efficacy of our programs. We establish our outcomes literally with the use of Drexel University, and we publish those outcomes. And they are, frankly, really very strong. And there's a reason, that today there are 200 people waiting on a wait list to find treatment at one of our Newport facilities. You're going to hear claims from our opponents, you've already heard some of them, that we seek to provide substance abuse treatment. That simply isn't the truth. I think, Mr. Moffett, you asked the question, what literally evidence? There wasn't any in the record that we provided, but our intentions are to apply to the state for a mental health license. There is a license for substance abuse. We don't intend in seeking that, and we screen our clients before they come into treatment. We do face-to-face screenings when they enter treatment, and we ensure that substance abuse is not an issue for them. Residents will have access only to the one home that they reside within. There will be no commingling of clients between houses, so each house will operate independent of one another. It will not be a congregate living by definition. Because we carefully screen and have a hands-on approach to mental health therapies, residents of our group home really don't pose a significant threat to our neighbors. I oftentimes hear we're going to bring people into the neighborhood who are not appropriate. The fact is, 1 in 3, 1 in 10 of our young people have illnesses that we can serve. We're living among them. They are living amongst us today. People we treat are like my own children, like some of your children, and likely some of your neighbors' children's. From zoning purposes, again, there were some references to for-profit versus non-for-profit. When I think about a family in crisis, I think they're not going to care what my tax status is. They're just going to want help. So I don't think it really makes a difference if we're a for-profit or a non-for-profit. Our job at Newport is to respond to this profound lack of residential treatment here in this community and in the United States. I'll turn it over, unless there's questions. And will we stop the clock? Yeah, sure.
Sir,
Please ask your questions. I wasn't on the
No question
microphone.
at all that what Newport is providing is a valuable and needed service for all of these young people. No question about that. But the county has already told you that that fits nicely into a congregate housing facility. Why are you trying to shoehorn this into 3 single-family homes? If you do the congregate housing route, you presumably will meet all those requirements. The treatment will be given. It clearly states that the residency, quote, can be on a temporary basis. So you have all those bases covered. But I have to ask you is, why are you here tonight trying to shoehorn this, once again, into 3 single-family dwellings, where, if I understand it correctly, the, quote, family in each one of these could change as often as every 30 days? So we'd have 12 families per house, in theory, every year. So why don't you just do the congregate housing route? Why are you doing this?
I would argue that we're not shoehorning it in as a group home. I would say that our treatment model is better served in a group home setting than it is in a congregate living setting. Again, we try to create a very family-like, comfortable, serene environment in a single-family residence. We've done that nationally now for 13 years, and we're doing it today here in the state of Virginia.
Couldn't you do it just as well in a facility other than a single-family home? Couldn't you
I would agree
provide the same standard of care?
I would agree that there is an option to do. Frankly, we provide campus-like settings as well, and we do that in other parts of the country. For our program here in the state of Virginia, we've opted for the group home setting.
Well, and another question is, I think you said would this be young adults now?
It is
Like
young adults, yes.
18 to 26, if I remember correctly.
That's
right?
correct, yes.
What assurances would the property owners have that each new family that comes in satisfies the requirements of the statute? If they're rotating in and out every 30 to 90 days, what assurances does anybody have is that each new group is going to fit the criterion of the statute, assuming that it applies to this situation?
The assurance I would give the neighbors and yourself on that is we have a very thorough screening process. We have a national call center where calls come in. We have our team collect information. A licensed therapist reviews that information. We screen a significant number of people out of services that aren't appropriate for our type of setting. And then when the client arrives at the facility, a licensed professional and a physician are validating that they're appropriate for our level of care and that they're appropriate from a mental health diagnosis perspective. You had asked the question, what type of assurance do you have? So you've got a physician saying the diagnosis of this client is major depressive disorder, which is the most significant group that we serve. It's roughly 67% of the people we serve have a diagnosis of major depressive disorder. So you've got a physician validation for it, you've got our clinical team looking at it, and you have our screening process at the very front end to make sure that the setting's right, because obviously we don't want to bring somebody into treatment who is inappropriate and have something untoward occur.
And then all of the young people coming in here have homes to return to, right?
That's correct.
What if they want to return home early? Can they?
Sure. We're a voluntary program, right? So we don't have locks. We alarm our windows and doors just so we can, again, keep our clients and the residents safe. But it's a voluntary program. They're not mandated by the state. They're not typically mandated by law enforcement to be there. So folks choose to come to treatment, and they can choose to leave treatment.
But once again, you're testifying that you can't achieve pretty much the same results by going the congregate housing facility route, which the zoning administrator has advised you is that you fit perfectly. So you don't want to go that route.
In this circumstance, no. I wouldn't say in all circumstances we wouldn't choose to go a different route. We choose to go the group home model here in Loudoun County.
Thank you, Mr. Chairman.
I saw in one of your documents you had a thing about how you act as a good neighbor, and I guess there was some discussion that came up of other instances that happened. I guess, can you elaborate on that?
Sure. So prior to acquiring the home, we distributed to all the adjacent neighbors here in Loudoun County our good neighbor agreement, and we have those in place in other facilities around Virginia. And so our executive director for the facility acts as a community liaison, and any issues that come up that neighbors have concerns about, she makes herself available to them to respond to those concerns. We have worked in this state now since 2020, and with some of our neighborhoods, like in Great Falls, we went to great length with the neighbors in that community. We have two homes that are on the same street, very similar type of situation, and we've worked with those neighbors to resolve matters that were important to them. They initially had filed an appeal, similar to the neighbors here, and they withdrew it because we were able to get to common ground with them. And we have offered that to the current list of neighbors, and they've neglected to accept that offer to this date.
Thank you.
All right, I do have a question. I'd like to touch on Mr. Moffitt's important point about assurances to the neighbors about standards being applied. And I heard you talk about licensing briefly, but you also talked about your internal procedures.
Sure.
I'd like to drill down into the question of licensure. with regard to that assurance. Is the nature of the license issued by the Department of Behavioral Health and Developmental Services sort of a one-time thing for the purposes of getting zoning, and after that you're free to do whatever you want? Or is there ongoing review? Are there opportunities for members of the community to file complaints or raise issues with regard to the Department of Behavioral Health and Developmental Services that could put your licensure in question, or are you off the leash?
No, it's all of the above. So we will make an initial application to the department. They will review our application. We're already a provider within the state, so that application process, that we're familiar to them. But there's a review process that occurs routinely, at least annually. If not, there's an initial, once we were to get home certified, they'll be out in 6 months to make sure that we're upholding the standards that we've agreed to and that we're following the policies and procedures of the state. And then there's an annual review that occurs thereafter. We're also certified by the Joint Commission. And so there's several accreditation and licensing bodies that are consistently in our records, reviewing our practices. The community can certainly file complaints with the department or with Joint Commission, really at any time, and then it's incumbent upon us to respond to those concerns. Again, our avenues, to Mr. Walker's question, would be to develop a relationship with the neighbors, that first call when they had a concern would come to us.
All right, so make sure I heard in there. I understand your internal procedures and everybody wants peace with their neighbors. Sometimes that doesn't happen.
Sure.
But you're testifying that there is a procedure by which, ongoing, if everything goes adversely in their view, that they'll have a continuing opportunity to file complaints and engage the state government to supervise the administration of your facility on this site.
That is correct. That is my testimony.
Okay, thank you. Any other questions? All right, then we'd like to hear from your attorney, please.
Sure.
And Stephanie, if you'll be ready to.
Mr. Clark, before you start the clock, one quick procedural matter.
Yes, sir.
We have written testimony from Celissa Lambert Woodard, who runs Pathway Homes, which serve Northern Virginia, including Loudoun County. Her testimony came later than we expected. I have written copies here. I think we've also tried to submit it, via the online comment piece. But I understand the rules of the BZA generally. I would ask, would the BZA make an exception here to receive this short report and CV of Dr. Woodard?
We have had to consider those in the past, so I'll ask the members of the board. Is there a motion to waive the regular rules and accept this, or shall we stand by the written rules?
So moved.
Is there a second?
I second.
All right, any debate about this? All right, then we'll move to a vote. All those in favor of accepting this additional testimony, say aye. Aye? Those opposed? It was an aye. 3-1, we'll take it. Thank you.
Mr. Chairman, may I have a copy?
Oh, of course.
I'm going to pass one.
And I'll ask if there's any objection. I think because this wasn't in the record that was submitted according to process, and Mr. Hampshire had to go first, I think he ought to be offered the opportunity at the end of your presentation to have a minute to respond to anything that's included in this, since it wasn't in the whole of what he came tonight to be prepared on.
Understood.
Does anybody have any objection to that? A little bit of potential rebuttal. Mr. Hampshire, I'll give you that opportunity if you so wish.
Thank you, sir.
But on this issue, not.
Limited to this letter?
Yes, sir.
Okay, thank you.
Okay. Thank you, Counselor.
Thank you, Mr. Clark and members of the board. I'm Michael Allen, partner in the law firm Relman Colfax, based in Washington, but with a national practice focused on housing discrimination issues. Much of my docket is housing issues for people with disabilities in various places around the country. I do want to say that appellants are just plain wrong when in their papers they claim that there's some kind of loophole here that Newport Academy has exploited in order to open these homes. In fact, as you've seen from the county's presentation, the zoning ordinance has remained the same since 1993 with respect to all of the operative definitions here, and there's been 20 years of consistent application of this definition of family to other similar situated situations over the last 20 years. Essentially, that holding is that small licensed group homes in single-family homes can be located in any district where a traditional family, related by blood marriage or adoption, is located, provided that it is licensed by the state. Newport came forth and asked the county for some information during its due diligence period. It wanted to buy 3 homes in a nice part of Loudoun County. It wanted to ensure that when it came in to apply for a license, that its reading of the zoning ordinance was correct. The zoning administrator's decision did no more than to say, if you're 8 or fewer and you're licensed by the state, then our zoning code, the Loudoun zoning code, would permit this use. Now, the BZA has to presume the correctness of the zoning administrator's determination here, not only because that's what the statute says, but because of the consistent application over all these years. The zoning ordinance does in fact follow the requirements of state and federal law. And if I could ask to have the second slide put up in my presentation. The Fair Housing Act in 1988 was amended to include people with disabilities. And Congress said in its legislative history, it is precisely to prohibit the application of special requirements through land use, restrictive covenants, and other sorts of ways that limit the ability of such individuals to live in the residence of their choice in the community. To Mr. Moffat's point, sure, there can be other places where people with disabilities can live, but in the same way that on the basis of race or religion, we won't say, can't you live in some other place in the community? We need to look and see what the language of this particular ordinance requires. So passed in the wake of the Fair Housing Act. Next slide, please. The Department of Housing and Urban Development and the Department of Justice, the 2 federal agencies charged with interpretation and application and enforcement of the law, have put out a joint statement on group homes and land use. This is from 2016, but the operative piece that I want to point you to here is, by definition, group homes are for people who are unrelated people with disabilities, and group homes, as discussed by HUD and DOJ, can be opened by individuals or organizations, both for-profit and nonprofit. No distinction under the federal law as to which they are. Next slide, please. The joint statement also answers questions. Can a state or local government enact laws that specifically limit group homes for individuals with specific types of disabilities? The answer is no. A government may not limit group homes for persons with mental illnesses to certain neighborhoods. And so, again, the zoning ordinance is passed in the light of the Fair Housing Act. Next slide, please. The Virginia Code was amended in 1990, also in light of the Fair Housing Act. And Mr. Clark, let me just say, you took the wind out of my sails. I think your reading of that provision with respect to use or addiction of controlled substances is absolutely right. It does not rob, it does not carve out people with mental illnesses who might also have a substance abuse disorder. But notwithstanding that, Newport's application and interest here, application for a license, interest expressed to the county for purposes of zoning, is not to serve people who have substance abuse disorders or needs. It's not detoxification. It's not drug treatment. This is for people who have the mental illnesses that will be appropriate to its license: anxiety, depression, trauma, eating disorders. Let's go to the next slide if we could. Mr. Hampshire spoke to you about the Board of Supervisors case, also sometimes known as the Kaleidoscope case from Fairfax County. And I think that that court put its finger right on the button here when it said, the statute is set up in a way that entrusts DMH, now called DBHDS, or we'll call it the state agency. By entrusting the state agency with the licensing duties, the General Assembly can be confident that consistent and reliable licenses are generated, and that's because staff of that state agency oversees the application process, conducts regular inspections to determine if the facility meets the statutory requirements. Let's go to the next slide if we could. The ordinance itself is also important, and Mr. Clark, I'll say, wind out of my sails again. The Board of Supervisors in 1993 looked at the state statute, looked at the Fair Housing Act, and determined that its own ordinance at the local level should have no space, no gray area, no doubt. If it's covered under 2291, we cover it too. That's the surest way for the county to stay in compliance with the state law and with the federal law. Let me just say that when a party does not have a good legal argument, you'll hear a lot of other kinds of arguments: property values, safety, quality of life, allegations about drugs. I think the bottom line here is, I understand the concerns of neighbors. Newport wants to be responsive to those concerns. But the bottom line here is that it is not the boogeyman that it's made out to be, and that you'll hear about alleged later tonight. One other thing I want to say is I'm going to take issue with the zoning
30 seconds.
with the zoning administrator's determination, and that is to say, the ordinance itself defines a congregate housing facility as something other than a single-family home. By definition, these 3 single-family homes on Gleedsville Road are not congregate housing facilities. This is the option that the Board of Supervisors allowed. You can be in single-family homes. You can be in a commercial district as a commercial house, some sort of commercial facility, a congregate housing facility. Newport chose the former. Thank you very much.
Thank you very much.
Happy to take any questions.
Stay, I'm sure we'll have some questions. Any members of the board have questions? Mr. Moffett?
Yes, were you going to? Let's talk about the definition of family for a moment. This exception is carved out for, quote, a family. In group homes under 2291, we're talking about a family, a dwelling, single family detached, a residential dwelling unit other than a portable dwelling designed for and occupied by one family. Your emphasis on there. And 2291A is all about family. And you yourself said the fair housing was devised to prohibit discrimination against a family.
I don't believe that was what I said. I said discrimination against people with disabilities.
People with disabilities. But here, and I understand that, so the single-family dwelling is really intended for a family of persons with disabilities, is where you have a situation, and once again, I repeat, what my understanding of that is 8 individuals who've been considered to meet the requirements of the statute come together, live there. That's their primary residence. That they live there with the intent, as I think the council said, is if they leave, their intent to come back and to live there and to be incorporated into the community. I just don't understand how a model where people are in and out, possibly every 30 days, and where the people are constantly shifting there, how does that make that a family within the intent of this? There's no intent to, quote, live there any more than there's any intent to live in a hotel if you're on a 30-day TDY there. So people can be in and out in 2 weeks. They can be in and out in 3 days. And so someone else comes in, and do we have a new family? I just don't get it.
Every federal court to consider this issue under the Fair Housing Act has indicated, first of all, that there is no requirement that people live there for the rest of their lives, or that they live there for any fixed period of time at all. For the time that a person at Newport, a Newport client, is in residence, he or she is going to be there for purposes of getting treatment. And every day that person comes back, that is that person's home. So the language in the Fair Housing Act has been interpreted by courts to say, no question that short-term stays are covered for group homes for people with disabilities. In the Newport model, the emphasis is not, with all due respect to your uncle, The emphasis is not to create housing for somebody for the rest of their lives. And Congress didn't mean to confine the Fair Housing Act protections to that. Newport's approach, as Mr. Procopio told you, is to get in and to provide intensive services to people at the time in their lives when mental illnesses are just manifesting, give them and their families the coping skills they need to do well back in their home communities, and then to serve others who are facing the very same kinds of concerns. Mr. Procopio told you that the Drexel University studies document the effectiveness of this particular kind of approach, and a more congregate approach may simply be less effective for people with the intensity of anxiety, depression, trauma, and eating disorders that present at Newport. Finally, I would say this. The Board of Supervisors made its decision for you in 1993 when it defined family in the zoning ordinance as it did. It could have done otherwise, maybe subjected itself to some liability for noncompliance with the state statute. But it's been settled law for almost 30 years now. Family includes anybody defined in 2291, period.
Even if that family, that quote, family, is in and out, constantly changing.
Sometimes when I make arguments to a judge, the judge says something to this effect. That argument is for the legislature. So the Congress decided that there shouldn't be occupancy minimums. You wouldn't have to say you have to be a certain number of days in order to be in there. The General Assembly imposed no minimums whatsoever. In fact, in 2000, SB 449, which attempted to make this distinction between nonprofits and for-profits, also had a little flavor of that, which is people are here short-term. The Attorney General said, listen, don't mess with this. You're going to violate the Virginia Fair Housing Law if you change this statute. As a practical matter, the state legislature has decided this too, and finally the Board of Supervisors has decided for the county. It could have said otherwise. It could have said, when we say a family means anybody covered by 2291, we mean they have to stay there for 60 days. That might be consistent with state law, it might not be, but it's not what they said. I think the board's job tonight is to apply the law as it's written and as it has been enforced for the last 20 years and more.
Why doesn't 2291 congregate housing facility says a structure other than a single-family dwelling where more than 4 unrelated persons reside under supervision for special care, treatment, training, or similar purposes on a temporary or permanent basis? If your argument is correct, why doesn't 2291 incorporate those groups from the definition of congregate housing facility?
Well, because the county's definition of congregate housing facility does not require state licensure. So you don't have to go to the state to get the approval in order to qualify as a congregate housing facility. You just need to meet local requirements. I think that the Board of Supervisors did the following. It said there are 2 ways that you could be here serving people who need special care, treatment, or training. That is, you could go the congregate housing facility route if you want to, but we also offer another lane for you. If you want to be in a residential neighborhood because your program works best, where you have a smaller number of people living together, where you have more tranquility. And if those of you, if you're not familiar with these houses on Gleedsville Road, they are on very large lots. They're tranquil, there are wind chimes, there are birds flying around and singing. There are ponds and streams. It is a definition of tranquil. I guess what I'm saying is, Newport was offered a choice here, and Newport opted for this approach, which has been successful for it in other places around the country for 13 years.
Mr. Franco, Walker, one, I'd like to push back on the residency. I'm not sure that I buy that the state statute is moot or says nothing about residential. I think it uses the word twice. Zoning ordinances for all purposes shall consider a residential facility, so not a football stadium, as blah blah blah, as a residential occupancy. Now, I'm a lawyer, as people may have picked up at this point, but I'm an elder law lawyer, okay? The context in which I deal with that, in Medicaid, there's a sort of a famous case of a fella in a recreational vehicle who owned no home. He was a pox upon his children. He would drive his RV from state to state and stay as long as he wished. And I think it was in New York. He arrived at his daughter's house in New York with his RV, left it in the driveway, and chose that night to have a stroke. And it was a question that was litigated as to whether or not that man was a resident of New York and entitled to New York Medicaid services. I need your help here. Can you tell me, is it not true that the Virginia definition of residency is where you are with the indefinite intention of remaining? That is to say, it's different than domicile, which is a permanent residence. But residence is, I'm here until I decide to not be here, as a fair estimate. Or do you think there's a different definition?
Well, I guess I would say the following, that I don't believe the definition is confined to indefinite intention to stay, but I would say that interpreting what federal courts have said about the Fair Housing Act and the idea of what is a dwelling unit, the courts have typically said it's the place where people have the present intention to stay for a period of time. So, and then as to the question of this residential use, I think you make the distinction appropriately. There are all sorts of uses available to structures in Loudoun County and everywhere else in Virginia. There's no question that this is a residential use, right? There's no question that the Newport clients who will live in these group homes on Gleedsville Road will sleep there, will eat there, will commune there, will do their studies there, will get therapy there. All of those things are things that you and I do in our residence, right? They're not operating a consulting business. You know, they're not operating a landscaping business. They're living there. So it is, in fact, a residential purpose. And I think the language in 2291 focuses not on length of stay so much as it does the essence of what people living there are doing. And if they were using it for a commercial purpose inappropriately, then there ought to be a sanction for that. And I would say, to a question that one of the board members asked earlier, there are many safeguards in place for neighbors. Apart from Newport's own goodwill and desire to resolve problems at the lowest level of conflict, the county has all sorts of authorities that it could enforce health and safety, if the grass gets too high, if there's too much noise, if there's a fire hazard, if the building is not in good shape. And the state agency can do inspections, scheduled and unscheduled, surprise inspections to ensure that the appropriate requirements are being met. I think the appellant's papers actually include, submission to this BZA, actually include the name of the person at the state agency who takes these complaints, and perhaps an evidence of complaints having been filed in other instances. Newport wants to work with neighbors, wants to be a part of this community, wants to be fully integrated and to work and to achieve all the things that other people living in Loudoun want to achieve by living here. And we would say that the state, federal, and local law all permit that as of right.
Mr. Chairman, I do have another
Please.
question. When a new class comes in, let's just call it a class here.
Well, can I quibble with your premise? When people may stay between 30 and 90 days with an average of around 45, which is what our papers provide. But people come at all different sorts of times, so there aren't classes of people.
All right.
If I get to my 45, 60, or 90 days and I'm ready to go, I leave, somebody comes in off the waiting list. So as a practical matter, there's more continuity than the premise of your question allowed.
Incorrect word. I apologize for that. When one person goes, another person comes in, who determines whether he or she fits the statutory requirement of mental illness here? How is that decision made?
Well, Mr. Procopio told you about what's done from the Newport side of things, and the state agency ensures compliance with the license. If any member of the community believed that a new resident at Newport didn't meet the definition, presumably that could be questioned through the state agency. It could be done through...
How would they have any idea? People coming and going. I mean...
My point is, there's a license, that requires Newport to comply with specific requirements, to admit people who have the mental illnesses listed in its license. At some level, I suspect that what I'm going to say is that you need to believe that Newport is going to comply with those requirements. If it doesn't, there are sanctions for noncompliance. And so rather than talk about hypothetical things that may happen, let me just focus on the fact that there are remedies available to people who believe that Newport isn't doing what it says it's doing. At this point, all we have is the hypothetical. Newport just wanted to know, can we buy these homes and do we understand the zoning ordinance correctly? That's all we have so far. No license application, no zoning application. Newport, I think, is eager to defend the merits of what it's trying to do here and not caught up in the procedural piece. This may or may not be the time to do that because there simply isn't a factual record on which to deal with allegations of drug use or commercial activity. And as a practical matter, we're so hypothetical here. I don't understand really how any group home, under the appellant's view, could ever pass muster to be in a residential neighborhood. It's not the commercial or for-profit nature of Newport that makes the difference. It's going to be 8 people in a group home, 8 people in another group home, 6 in the smallest of these 3 homes, by the way. No application filed yet, but I'll make that representation. Any group of that number of people, for-profit, nonprofit, commercial, non-commercial, would likely raise the concerns, the hypothetical, the speculative concerns that you've heard tonight and will hear more tonight. So as a practical matter, we're on a hypothetical record here. If the board were to hold that Newport cannot be established here for some reason, it'd be hard to think of any group home that could be established in an AR1 district, notwithstanding what the federal, state, and local laws say.
Any other questions? Okay.
Thank you for your time.
Thank you very much. I think in fairness, because we did have the submission of a statement by Dr. Lambert Woodard, is there any objection from the board with me allowing Mr. Hampshire a minute to respond if he'd like to? Or maybe I should ask if you have a statement to make.
My understanding, Mr. Chairman, is I'm limited to this document and,
Yes, sir.
and the consequent. I do have something to say about it.
All right. Is there any objection to us allowing him to speak to this document? All right. Mr. Hampshire, the floor is yours.
Thank you very much.
Stephanie, 1 minute.
So I'm looking at this document, and I haven't had a chance to read it thoroughly, but what it clearly talks about is the need for the services. And I just want to say that we do not dispute there's a need for the services. We don't dispute that there is therapeutic services that are intended. In fact, that's really our whole point. If you look at the conclusion of this document, you will see in summary and so on, in the last paragraph, therapeutic value of living in a healing community, community resistance, etc. And then it goes on at the last sentence, the program will add to the existing array of services and allow residents to receive care close to home. We are not talking about a home here. We are talking about services, therapeutic services that are not in their home. It's in a treatment center with the intent not to reside there for any period of time, but to go home. And when a young woman walks through that door, it's her intent to be treated and return to her home, her real home. That's different. It doesn't matter whether it's 2 hours, 5 days, 3 months. She does not have the intent to reside in that house. But I want to say that we don't have to get to the issue of reside, because it remains that this is not a residential facility, regardless of how long people will reside there. It simply isn't. And the protection of 2291 is limited to residential facilities, which mean, under the Loudoun County Zoning Ordinance, as we say in our papers, is a place where people reside and do the things that private homes in Loudoun County do. Thank you very much. My time's up.
Thank you, Councilor. All right, that's the 3 parties' presentations. I'm going to go out and say I've been doing this for 15, 17 years. I can't recall a time when I felt the parties so respectfully and clearly were helpful to this board about getting to the gravamen of the issues and not getting off into what clearly can be some emotional questions. So next is our public hearing portion. I do have to ask for the board's indulgence again. I've been passed a note from the secretary that one of their esteemed members of the Board of Supervisors